Hi, I'm Yolanda with Tailored Realty, and thank you so much for joining us today. We are starting off our series on Did You Know? We want to know, do you know? And on today, we have a featured guest in our office, Judge Amy McCulloch, who is the probate judge right here in Richland County. Or is it for an entire state?
No, we're just Richland County. My
Richland
goodness. A promotion right here on the air.
Right. So for Richland County, we are just so thrilled and we're grateful to have her in the studio with us on today. And we want to share some information that I know that you are probably looking for, as I have been looking for. And she has been with Richland County now for 26, 27
This is my
years.
26th year. So this is starting my 26th year. Yeah.
Wow. So we're
fortunate.
Really, that's an awesome thing. And so, I've had an opportunity. Unfortunately, I had to go through the probate system when my father passed. And it was really, they made it a simple process, but there were things that we found that we didn't know about. And so here we are today. We want to share some things with you. If you have questions, please feel free to note them down, and we will definitely try to get to them as soon as we can. So, again, thank you so much, Judge McCulloch, for joining us today. Can you tell us a little bit about yourself and how you decided, what made you decide to go into probate?
That's a great question. I tumbled my way into probate, but I grew up here in Columbia and went to Dreher High School. We were just speaking on that. USC undergrad, USC Law School. I started off as a prosecutor for Richland County. So I was prosecuting crimes for Richland County for about 5 years.
Okay.
Then I went into private practice with my husband and learned an array of the private practice world, and then ran for probate in 1998.
Wow.
It was a long time ago. Yes, and was fortunate to win that election. It is an elected position. Most people don't realize that. You vote for your probate judge, which is unlike any other judicial position in South Carolina. So the people decide who their probate judge is going to be. And I have been super fortunate to continue to get your approval and continue to stay in this job for all these years. So I'm very fortunate. Probate is just an amazing part of our law that is often misunderstood.
Mm-hmm.
Often undervalued, but it affects every single one of us at some point. So it's a pretty important part of our structure and our community. And probate is there to give you the ability to transfer assets at death, but we do a lot of other things. So kind of understanding probate is an interesting part of maybe our conversation today.
Yeah. And because sometimes we really don't know, other than, if someone dies, we go to the probate court and this is what we need to do. So we want to bring value to our community. So for our listeners who may not be familiar, can you tell us a little bit more about how probate is different from any other courts?
Yes. So I think we touch the family more than probably any other court. You may never have to sue somebody. You may never be in a car wreck that would require you to go to court. You may never have to evict somebody or be evicted. All those things that you see other courts are there for. But probate will touch you. At some point, you will lose a loved one. And at some point, those assets will need to be transferred. And the structure of our probate court is to make sure we're following your directions, right? We want you to have a will. That will is so important. If you have that will, it speaks to how you want your assets transferred, and almost more importantly, who you want to be the personal representative. Who do you want to be in charge to oversee the transfer of these assets? So that person you trust the most, that person you understand is most business-minded, has their own personal structure in order to allow for them to be your best choice, because you're not there anymore.
Right.
Yeah. And who you trust to do that and speak for you and handle your assets after your death is super important. Picking that right person. We also do so many other things. We're the court you come to for marriage licenses. So clearly we've touched everybody in our community who's gotten married. We also handle guardianships and conservatorships. So you can imagine if you have not planned and don't have a power of attorney in place, there may be a point in your life where you need to take care of someone in their financial world because they've become incapacitated. And so without that financial power of attorney that they've chosen for themselves during a period of capacity, we are responsible for making sure we appoint the proper person to be the conservator, to manage the assets, to make sure the bills are paid.
How do you go about appointing that person when,
Yeah.
here you don't know them, you don't know the family? How does the court go about appointing or finding that guardianship?
So our law gives us the structure. When someone is asking to be the guardian or the conservator for an individual, again, this is during a period of incapacity, the guardian would be there for their health care, maybe making sure they're placed in the proper living arrangements. The conservator is there for the money part. So looking at who the law says is who we're supposed to look for. So if it's me and I'm married, the law says look first to the spouse. If it's someone who's unmarried, look to all the children equally. And that's typically where our contests come into play. If you have more than one child and they do not agree as to who would be the best person to take care of mom or who would be the best person to pay mom's bills, and we have to have a hearing on that, we're then talking about the very things I was just speaking to. How are you doing in your own life? How would you handle mom's assets? And so we're looking for the best person who has lived their best financial life or has lived their best nurturing life in terms of taking care of mom. And that could be two different people. Sometimes we have more than one child where you have a nurturing child, the one that's there for you, that's going to take you to the doctor. And you may have a more business-minded child who's there to make better choices as to the bill payment and the priorities and the asset management. The issue there then, though, is they must work together. Right. With healthcare comes costs. So the person who's paying the bills has to work with the person who's going to be the nurturer.
So then the person that's actually taking, I think I just answered my question, that's going to be taking care of the bills, this is going to be from the finances of the person that's incapacitated.
Yes, ma'am.
Okay. So how do we go about avoiding having to allow the courts to do this?
Such a great question. So we spoke about the will already. That avoids a lot of problems after death. But more importantly, you're still alive. What could you do right this second? There is in our state a state-approved form called a healthcare power of attorney. It's on my website. It's on many websites. Make sure you're using the South Carolina healthcare power of attorney. And that names the person you want to be in charge of you. Again, that guardianship piece, that nurturing piece, who's going to take care of you. And then going to an attorney, just like you would have someone draft your will, you need someone to draft you a financial power of attorney, durable financial power of attorney that allows you to pick who is going to be in charge of your assets. But in making your choices, making sure, again, that if you're choosing two different people, one to be your nurturer, caregiver, one to be your business-minded financial asset person, they've got to be able to work together.
Agree. Okay. And so I guess, and I was trying to kind of put them all together here. And as far as the will, and I know we encourage people to always do wills. That's hard to talk with sometimes. It's really challenging to speak with your parents or your spouse about wills. But tell us the challenges, if you would, that you have been seeing in your court when there's not a will, or can we come to the probate court if we don't have a will?
Yeah. So let's talk about when you don't have a will, what happens. And let's talk about a few scenarios. You may be a married individual. So again, just making sure we're very clear on marriage in South Carolina. We've abolished common law marriage. So we're talking about marriage license exists that says you two are married. If you're married and you don't have children, neither one of you, 100% of what you're leaving behind will go to your surviving spouse. So you may do just fine in that scenario.
As long as there's a marriage license. If you're separated and there's a marriage license still in place, 100% goes to that person.
And that's an unintended consequence you just brought up. That's great. So if you are separated and are considering yourselves living two separate lives now, but you have not legally divorced, you are married. And without an agreement, just like you have an agreement maybe to separate your property, an agreement that says you own the house, I own the vacation property, you own this car, I own this car, we're going to separate our assets. If you haven't agreed on paper as a contract to not inherit from each other, I die, you inherit 100% as my legally married spouse.
Okay.
That's a really important unintended consequence.
And I know that in the past, there has been for years and years and years. And when I actually met you at the workshop, this was an eye opener to me because I wasn't aware that there was no more common law marriage.
Right.
Because what was it, after 7 years or after 10 years?
There really wasn't a
living
time
together?
frame, which is
It
why
wasn't.
which is why we abolished it.
Okay.
It was too arbitrary, too bizarre, too hard to interpret, often very fraud ridden. Like I'm going to be married on Monday when I go to this business meeting, or maybe to church on Sunday, but on Friday when I do my taxes, I might get a better benefit if I file single.
Okay.
So people were not understanding common law marriage and maybe tipping over it and messing up. And even if you considered yourself common law married back then, because we've abolished it, to be clear, you had to, at death, it ends, and you had to come back to court, to probate court, to claim it in a lawsuit. And sometimes people were suing their own children to be able to be determined common law spouse. Now imagine if you had common law spoused yourself to someone who had children from a previous relationship, they're certainly going to, or most predictably, object to you claiming spousal status.
Right.
Which all those controversies we tried to work through, and the one person that we needed in the room is no longer there to speak.
Right.
So abolished.
Wow.
Gone.
Okay. Okay. So, and that's good. Thank you for sharing that. So we are encouraging, from what I'm hearing, wills.
Absolutely. Absolutely. We need you to speak to how you want your assets to transfer. We need to speak, more importantly, who you want to be in charge. And I think the person that struggles with this the most is a person in a second marriage with children from a previous relationship or marriage. So there's already conflict. And you may have come into the marriage with assets from your previous marriage that your children are going to want. And how you speak
and
to
feel
that.
entitled to,
And
oftentimes.
feel entitled to. And then you've accumulated, no matter how long the second marriage is, you've accumulated of the marriage. And that gets complicated. What was theirs before, what was theirs during the marriage. And those are oftentimes the fights that we see. Children from a previous relationship dealing with second spouse. When you don't speak in your will, you are setting up that very fight.
Okay. Okay. All right. So, well, thank you for that. I appreciate it. And I'm sure there's a lot more behind it that we could say. We want to go ahead and get some other things out there too, so that people can have an aha moment. So tell us any misconceptions that we have here in the public as it relates to probate and your department altogether.
So I'm going to give you a little scenario that we were just kind of talking about before we went on air.
Okay.
Sometimes when we're married and we own our house together, we assume it automatically passes at death to the surviving spouse. And depending on what your deed says, that could be the case. So if your deed reads joint tenants with right of survivorship, you are in that scenario. Your house will pass to your surviving spouse at your death. But if your deed does not say that, and this is where we urge people to go and look, if your deed does not say that, you own your house 50-50. And so if you wait to probate, it could get more complicated, because as it seems a long time, we have a 10-year statute of limitations to recognize a will, but we also have a 30-day window when you're required to file the will. So we don't want people to wait, because if you wait, and I, as your spouse, left you the house in our will, and you've waited more than 10 years, you don't get the house as described in the will. You will get per intestacy. So if we have children, if I have children, half goes to the children, half goes to the spouse. And if that wasn't intended in the will, you've waited too long to fix it.
And then you're looking at a 10-year time frame. Now you have more children involved and grandchildren involved, and people have a say in it, because you're 50%. Now I'm a part of that 50%. Is that how it happens?
If we're in intestacy, yeah.
Okay.
Yeah. And so imagine that all these years, I didn't realize I needed to go to probate, and there was a mortgage on the house. And I've continued to pay that mortgage out of my own pocket, keeping it safe, keeping the taxes paid, keeping the house insured, maybe doing upkeep, whatever it is. And now that door is open to potential other heirs because I didn't probate in time. So not waiting, I think, is a good urgency for people, even though we have that time frame. Please don't wait. Don't delay, because at the death of the second parent is usually when we realize we've got to go and not only probate dad's estate, now mom's estate,
Right.
and the time frame and expense of that can be complicated as well.
Okay. Okay. Very good. And then it gets even more complicated if both die and did not have a will.
Right.
Okay. Can you, in understanding the Privacy Act, are there any notable cases that you can share with us that that will help us?
I think I could share scenarios.
The challenges of them.
Scenarios.
Okay. Yes. Okay.
I think one of the things I think about over the years of doing this is how interesting people can be in the courtroom at the time of this experience. They can be very interesting. The fights about what and what it really boils down to. And I think there's so much of that is psychologically intertwined with our family traumas, intertwined with our family relationships, because what they come to court and ultimately are fighting about can be so petty as it appears to the person who's just looking at the value of the thing they're fighting about. And I'll give you a little story. It's an interesting story. I had 3 children. It was at the death of the second parent. And that's usually when the wheels go off the bus. I mean, mom has maybe the second parent and she's kept everybody in check. But at her death, the 3 children were fighting over a coin collection. Now, wait, you might think a coin collection, that could be very valuable. That's not the kind of coin collection I'm talking about. You know, that kind of person that goes in at the end of the day and just takes the change out of their pockets and puts it in a jar. Jar. That was the coin collection. And they were made by me to bring the jar of coins to court. Now, all 3 of these kids had attorneys. So they're paying an attorney to fight over the last thing, which was this coin collection, where we then dump out all the coins on the table. And one son really believes these coins are so super valuable that he thinks they need to be appraised. And I said, well, let's at least start with looking at them. What about them looks special? Maybe we should put them in piles. So now we're taking time to make, $50 piles, quarter piles, dime piles, nickel piles, penny piles. And he goes, well, you're probably right about everything except these pennies. These pennies, I think, are really valuable. He believed that because some of them, maybe a lot of them, were wheat pennies. You know what a wheat penny is.
No, I actually don't.
It's many years ago, there was a penny that was made with wheat on the flip side.
Okay.
Yeah, wheat pennies. And he believed that those wheat pennies were extremely valuable. So we broke court for him to take the wheat pennies down the street to have them looked at by a coin person, and then to come back together, come back to court. Now, remember, we got 3 attorneys all this time going by. He goes down the street, he comes back, and the wheat pennies are worth a penny. And we have waited all this time and all this expense because of. Wow. Yeah. Wow. And I that's an interesting story, but it's a very typical example of where we get caught up in, maybe I don't want you to have this. Not so much I want it. I just don't want you to have it. Yeah. And that really clouds people's objectivity and good judgment. Yeah.
And you make a very valid point in that, when one spouse dies, it's okay because the other one is kind of holding things together. But when the other one dies, and now we have to deal with all of this stuff, because in most cases it'll go from one spouse to the next. And now we have, no spouses here. Let's divide the coins. Yeah.
Yeah. And I think it kind of makes the point that when you've got more than one child, and your will says, I want them all treated equally. What is that? What is that? If you're leaving your house, maybe a car, some money in the bank, if you're lucky, a few other things. If that's your asset package, how do 3 kids equally share that? And how do you lead them into the equality of that? And I think it's a huge misconception that the house can stay in the family. I hear it all the time. Mom wanted us to keep the house in the family. Well, how does that ever become fair? are we all going to live together in it with our families?
Mm-hmm.
It just doesn't work.
Mhm.
And so when you get to that place where the family has to either agree to sell it, agree to let one of the children buy out the other two,
Mm-hmm.
that is the disruption in maybe what they've been told their entire life.
Mm-hmm.
Keep
Mm-hmm.
the house and the family
Mm-hmm.
as the gathering place.
So then within the will, being specific is going to really, really matter all the
And
way
giving
down to the
permission to
jewelry.
sell it.
Yeah,
Giving
giving permission. That's a good point.
I think there's also, when you talk about jewelry, that's a lovely thing to fight about, because it often is, maybe my mother's jewelry box has always contained these very specific items of jewelry. Maybe she wore them with great frequency, and maybe she talked about them, and maybe she said, I really want my granddaughter Sally or Mary or Josie or whatever to have certain pieces.
Mm-hmm.
Be specific in your will.
Mm-hmm.
Be specific.
Mm-hmm.
And if you can't be specific in your will because you're not sure yet, be specific in your memorandum of tangible personal property, which is that list we're allowed to keep of the things in our house and how we want them to go.
Mm-hmm.
To be clear, our will needs to tell us it's there, or it
Mhm.
could be there, to
Mhm.
look for it. And to be clear, as you as the individual, you may gift things during your life. You may give
Right.
Josie that brooch. You may
Right.
give Mary that ring.
Mm-hmm.
Mark it off the list. Make
Mhm.
sure you're acknowledging those things have already been gifted, because what we have at the end of the day is jewelry is very, it's not like a title document, right? It's not like a
Mhm.
title to a car where you
Mhm.
know it's there.
Mhm.
Jewelry moves.
Yeah. Yeah.
And the other thing that's very difficult to deal with is guns.
Really?
Yes.
Okay.
Because guns are
That's
not followed
collections.
by,
Yeah, that's right.
yeah. And you may gift a gun during your life. Your gun may be borrowed. I don't know. I don't completely understand gun ownership. It doesn't make me completely comfortable. But in the South, we have guns, and that's guns and jewelry are very hard things to document. And then how you rectify it's not there anymore at the end of the day.
Mhm.
Between death and probate, what happened to that jewelry? What happened to that particular gun? It's very complicated.
Okay, very good. Now tell us, and I know just as in real estate and any other career, things change, they evolve, and tell us what type of changes. I mean, you've been with our probate judge for decades. So what type of changes have you seen that we would need to know about how it would affect us?
Well, one we've already
Most
touched
recent
on.
one. Mhm.
One we've already touched on.
Mhm.
And it's probably the most recent gigantic change in probate, which is abolishing common law marriage.
Mhm.
And I think the more we communicate that, because I think there are still people in our community, because this decision came down in 2019, and that was not that long ago.
Yeah.
And it was, during a period of maybe not paying attention of COVID, right? We had COVID that kind of knocked us right in the jaw right after that.
Mhm.
We still need to communicate to people who think they're in a common law marriage. It is almost impossible now even to look back to 2018 and before
Mhm.
and prove it,
Mhm.
because now you are on notice, it's abolished, and now you are on notice, you need to come and get a marriage license.
Okay.
Without that, you are complicating your life so much if you
Mhm.
think you're going to get to claim it later.
Mhm.
It's really something we're still talking about. So making sure that if that's where you are, you need to grab your partner by the hand and come get a marriage license.
Right.
And
right.
I'm gonna look at the camera. If they refuse to go with you to get a marriage license, something's up.
Yeah. Right. Absolutely. Because after you've been married, well, anyway, that's another subject. Nonetheless, I will keep moving on. Are there any other things that you'd like to share with us that you've seen a lot that come across in your department that just if the community knew this, it would make your job easier?
Well, the concept of mom didn't own anything,
Mm-hmm.
I think can really come back around. When you go through what you think mom owned and how it was titled, and making sure there's no leftover assets, and I'm using mom, but of course it could be dad, of
Right.
course it could be your spouse.
Mm-hmm.
You make sure you look for the things that could be needing probate to transfer.
Mm-hmm.
If there is a will, your mother went to the great effort to have that will in place. If there is a will, And even if you think mom has no assets, you still need to bring the will to court. Let me recognize it. Let me probate it so that when you do find something, or if you find something, we can follow the directions of the will. So don't hold the will back thinking there's nothing to probate or no reason to file the will. Do that anyway. Many times families find money at unclaimed funds. You know, that bank account I didn't realize mom had. I had an interesting situation recently where a man realized his mother had been passed away for many years, and he had probated the will. He found $100,000 in unclaimed funds for a bank account he did not know his mother had had. Now, isn't that lovely?
So how does that work? Yeah.
So because we had the will, because he had already probated the will, we could follow the will and give him permission to claim the funds from unclaimed funds.
Wow.
Now, it may only be a much smaller amount, but let that look happen. Yeah. That's a good moment. Check unclaimed funds. Check the South Carolina Treasurer's unclaimed fund department. You can search online and make sure there's no assets that have been turned over that were unrealized. Oftentimes cars, you need to kind of look back at the car title and see what name it's in, because you may have thought mom sold it, thought mom transferred it, but making sure there are no cars in mom's name at her death, checking that. And a way to avoid probate, right? One thing, a little moment in time. If there's or on the car titles, if there's or between the names, it is a survivorship asset that you don't need probate to transfer for you. It automatically transfers. And the same would be true of a boat, a trailer, a motor, a mobile home, all those things that have titles. Putting or on the title between the names can avoid probate.
Well, let me ask you this then. What is the difference between having or on a title versus joint tenancy in common?
So you have deeds that must have those very specific magic words. Deeds, land ownership.
Okay.
Deeds must have joint tenants with right of survivorship.
Okay.
That's your magic word.
Okay.
For everything else that has a title, like a car, a boat, a motor, a mobile home, all those things we just kind of went through, it's or.
Okay.
And so look at your titles. Okay. See if there's anything you want to do now, be active now to avoid that probate necessity. And then we could talk about bank accounts, checking your bank accounts. Being joint on a bank account means I have survivorship. You have survivorship. We're joined on a bank account. I pass away. That bank account is yours.
Right. Do I need to wait to go to probate, or can I just automatically close it out?
Yes, ma'am. That's automatically yours. And sometimes that's an unintended consequence of adding one of your 3 children join on your bank account for ease of process. You may, I may have added you to my bank account so that you could help me pay my bills if I became incapacitated. But I did not know or intend for you to take the total of whatever's left. I intended per my will to share it with all my children. So that could be an unintended consequence.
So if it is like that, Judge McCulloch, so I have a bank account and my spouse is deceased. No, my spouse is deceased. My child is, I have 3 children and only one of their names on it. And as you said, they can go and close out that account.
It is their money.
It is their money. What if the will states something different in terms of, if the will states that once I'm deceased, then all my children get everything equally? Would that include that account?
No, ma'am.
That's not included because,
It's like a contract with your bank. You are involved in a contract relationship with your bank where you're saying, this is what I'm telling you to do, bank. By having this joint account, it will only pass to the survivor on the account. Gotcha. And I think banks are getting better about having you acknowledge that on the forms that we now fill out. So you may want to just kind of look back at that as your check moment. If we're bringing anything to the table, these are check mark moments. Like, I need to look at that.
Very
and
good.
The same is true with anything else. If you can name a beneficiary, always do so.
Very good. Okay. Do we have questions or, okay. I don't know anything.
2 minutes?
2 minutes left.
Ah.
Okay. So we're going to thank you so very much for all this valuable information. I've taken a lot of notes. I hope that you have also. If you have any questions, you can reach out to us and we can definitely reach out to Judge McCulloch. 803-422-2226. So again, I'm going to close and encourage everyone to please check with your parents, check with whomever you need to check with to make sure that we're not going to be stressed out because of a loss of a loved one, because we know that we're going to have that will in place. We'll have everything taken care of, and we will be able to move forward. Any closing words that you may have for us, for our audience?
I echo what you said. Thank you. Talk to your family members. Please know that we're here for you. Richland County Probate Court will do our best to answer your questions and assist you through any of these difficult times.
Thank you. We wish you well, and thanks for joining us.